Laws about BAC levels below 0.08. Understanding the legal implications of blood alcohol concentration, BAC, levels is critical, especially since even low levels of alcohol can lead to driving offenses. This is particularly true in New York, where a BAC level between 0.05 and 0.07% can still result in charges. Although driving with a BAC of 0.08% or higher is categorized as driving while intoxicated, DWI, the law also penalizes drivers for impairment at lower levels under driving while ability impaired, DWAI. Knowing the laws surrounding BAC levels can help drivers make informed decisions and avoid legal troubles. Legal considerations regarding BAC limits. While the legal threshold for a DWI charge in New York is a BAC of 0.08%, drivers with BAC levels between 0.05 and 0.07% can still face consequences. This range falls under the charge of driving while ability impaired, DWAI, a lesser-known offense. DWAI is taken seriously by law enforcement due to its impact on driving ability, even when BAC is below the DWI threshold. Penalties for DWAI may include fines, mandatory jail time, and short-term suspension of driving privileges. New York's zero-tolerance law applies to drivers under the age of 21, prohibiting any BAC level above 0.02%. Violators can face penalties, including a 6-month license suspension and fines. Repeat offenses can result in harsher consequences, such as a 1-year revocation of driving privileges or until the driver turns 21. Additionally, commercial drivers face stricter BAC limits, and penalties for violating these can include extended license suspensions. It's essential for individuals in this profession to be extra cautious as their livelihood may depend on maintaining a clean driving record. Understanding the impact of low BAC levels. Drivers often assume that they will only face legal consequences for high BAC levels, but the reality is more nuanced. In New York, even with a BAC between 0.05 and 0.07%, you can be charged with DWAI. Unlike DWI, which requires a higher level of intoxication, DWAI reflects a lower level of impairment, but it still signifies that your ability to operate a vehicle is compromised. The state has these measures in place to ensure the safety of all drivers on the road, acknowledging that even slight impairments can lead to accidents or dangerous situations. Law enforcement officers in New York are trained to recognize impairment through behavior and physical signs, even when a driver's BAC is below the legal limit for DWI. This means that your admission to drinking, or certain physical signs like bloodshot eyes or slurred speech, can lead to your arrest, even if your BAC is low. Officers may also request additional testing, like a urine test, to check for the presence of drugs. What happens when BAC is below the legal limit? Driving with a BAC under 0.08% but above 0.05% can lead to serious consequences. Although you may avoid a DWI charge, you could still face a DWAI offense. Penalties for DWAI include fines, jail time, and suspension of your driver's license. The state's goal is not only to penalize drivers but to emphasize the importance of road safety. Even minimal alcohol consumption can impair decision-making and reaction times, putting both the driver and others at risk. Law enforcement officers are cautious when it comes to BAC-related stops. Many drivers assume that if their BAC is under 0.08, they won't be arrested, but this is a dangerous misconception. If the officer believes you are impaired, you can still be taken into custody. In some cases, officers may request further tests, such as a urine test, especially if they suspect drug use. For this reason, it's always wise to consult with a lawyer if you are arrested under these circumstances. The process of handling a low BAC charge. If you are pulled over and suspected of driving under the influence, the officer may arrest you even if your BAC is under 0.08%. This decision is based on various factors, including your appearance, behavior, or admission to having consumed alcohol. Even if the initial breathalyzer test shows a low BAC, officers are trained to err on the side of caution. In some cases, drivers may be charged with common law DWI, which is based on the officer's judgment of impairment, rather than BAC alone. The consequences of such charges can be severe, especially for repeat offenders or commercial drivers. For example, any plea for a commercial driver could result in an 18-month license revocation. Likewise, underage drivers are subject to the state's zero-tolerance policy, which leads to immediate arrest and potential revocation of their license. Protecting your rights with legal assistance navigating BAC-related charges can be complex. Understanding the nuances between DWAI and DWI, as well as the specific laws regarding commercial and underage drivers, is crucial. If you are facing charges related to a low BAC level, consulting with a lawyer can be invaluable. A skilled attorney can help clarify the charges against you and explore all possible defense strategies. At Lebedin Kofman LLP, our Nassau County DWI lawyers are experienced in handling cases involving low BAC levels. Whether you've been charged with DWI, DWAI, or are facing penalties under the zero-tolerance law, our attorneys can guide you through the legal process. We strive to provide the best possible defense, ensuring that your rights are protected at every step. Contact Lebedin Kofman LLP today at 516-212-4209 and visit us at 600 Old Country Road, number 205, Garden City, New York, 11514, United States, for a consultation on your BAC-related charges. Let us help you navigate the legal complexities and work toward the most favorable outcome for your case.